The central point of Professor Hart's definition is that a crime is subject to formal condemnation by a judge and jury representing the people in a court of law. This distinguishes a crime from acts most people would find objectionable that typically are not subject to state prosecution and official punishment. We might, for instance, criticize someone who cheats on his or her spouse, but we generally leave the solution to the individuals involved. Other matters are left to institutions. Schools generally discipline students who cheat or disrupt classes, but this rarely results in a criminal charge. Professional baseball, basketball, and football leagues have their own private procedures for disciplining players. Most states leave the decision whether to recycle trash to the individual or look to peer pressure to enforce this obligation. Criminal and civil law. How does the criminal law differ from civil law? Civil law is the branch of the law that protects the individual rather than the public interest. A legal action for a civil wrong is brought by an individual rather than by a state prosecutor, who may sue a mechanic who breaches a contract to repair your car or bring an action against a landlord who fails to adequately heat your apartment. The injury is merely to you as an individual, and there is relatively no harm to society. A mechanic who intentionally misleads and harms a number of innocent consumers, however, may find himself or herself charged with criminal fraud. Civil and criminal actions are characterized by different legal procedures. For instance, conviction of a crime requires the high standard of proof beyond a reasonable doubt, although responsibility for a civil wrong is established by the much lower standard of proof by a preponderance of the evidence, roughly 51% certainly. The high standard of proof in criminal cases reflects the fact that a criminal conviction may result in a loss of liberty and significant damage to an individual's reputation and standing in the community. The famous 18th century English jurist William Beckstone summarizes the distinction between civil and criminal law by observing that civil injuries are infringement of the civil rights which belong to individuals. Public wrongs or crimes are a breach of and violation of the public's rights and duties due to the whole community in its social and aggregate capacity. Blackstone illustrates the difference by pointing out that society has little interest in whether someone sues a neighbor or emerges victorious in a land dispute. On the other hand, society has a substantial interest in the arrest, prosecution, and conviction of individuals responsible for espionage, murder, and robbery. The difference between a civil and criminal action is not always clear, particularly with regard to an action for a tort, which is an injury to a person to his or her property. Consider the drunken driver who runs a red light into a car. The driver may be sued in tort for negligently damaging you or your property, while as criminally prosecuted for reckless driving. The purpose of civil action is to compensate you with money for the damage to your car and the physical and emotional injuries you have suffered. In contrast, a criminal action punishes the driver for endangering society. Civil liability is based on a preponderance of the evidence standards, while a criminal conviction carries a possible loss of liberty and is based on the higher standard of guilt beyond a reasonable doubt. You may recall that former football star O.J. Simpson was acquitted of the murdering of Nicole Brown Simpson and Ron Goldman, but was later found guilty of wrongful death murdering in a civil court in order to compensate the victim's family of the amount of $33.5 million. The distinction between criminal and civil law immensely signifies for Kansas inmate Leroy Hendricks. Hendricks was about to be released after serving 10 years of prison for molesting two 13-year-old boys. This was the latest episode in Hendricks' almost 30 years history of indecent exposure and molestation of young children. Hendricks freely conceded that when not confined, the only way to control his sexual urge was to die. Upon learning that Hendricks was not about to be released, Kansas authorities invoked the Sexually Violent Predator Act of 1994, which authorized the institutional confinement of individuals who, due to a mental abnormality or personality disorder, are likely to engage in predatory acts of sexual violence. Following a hearing, a jury found Hendricks to be a sexual predator. The U.S. Supreme Court ruled that Hendricks' continued commitment was a civil rather than criminal penalty, and that Hendricks was not being unconstitutionally punished twice for the same criminal act of molestation. The court explained that the purpose of commitment procedure was to detain and to treat Hendricks in order to prevent him from harming others in the future rather than to punishment. The purpose of criminal law. We have seen the criminal law primarily protects the interests of society, and civil law protects the interests of the individual. The primary purpose of a function criminal law is to help maintain social order and stability. The Texas Criminal Code proclaims that the purpose of criminal law is to establish a system of prohibitions, penalties, and correctional measures to deal with the conduct that unjustly and excessively causes or threatens harm to those individuals or public interests for which state protection is appropriate. The New York Criminal Code sets out basic purpose of criminal law as follows: harm, to prohibit conduct that unjustified, excusably causes or threatens substantial harm to individuals as well as to society. Warning, to warn people both of conduct that is subject to criminal punishment and of severity of punishment. Definition, to define the act and intent that is required for each offense. Seriousness, to distinguish between serious and minor offenses and to assign the appropriate punishments. Punishment, to impose punishments that satisfy the demands for revenge, rehab, and deterrence of future crimes. Victims, to ensure that the victim's family, and community interests are represented at trial and imposing punishments. The next step is to understand characteristics of a criminal act, the principles of criminal law. The study of substantive criminal law involves an analysis of the definition of specific crimes, specific part, and of general principles that applies to all criminals. General part, such as the defense of sanity. In our study, we will review the general part of criminal law, look at specific offenses. Substantial criminal law is distinguished from criminal procedure. Criminal law procedure involves the study of legal standards governing the detection, investigation, and prosecution of crime, and includes areas such as interrogation, search and seizure, wiretapping, and trial process. Criminal procedure is concerned with how the law is enforced. Criminal law involves what the law is enforced. Professor Jeremy Hall and Wayne Lafave identify the basic principle that composes the general part of criminal law. Think of the general part of the criminal law as the building blocks that are used to construct specific offenses such as rape, murder, and robbery. Criminal act. A crime involves an act or failure to act. You cannot be punished for bad acts. Criminal act is called actus rea. Criminal intent. A crime required in criminal intent or mens rea. Criminal punishment is ordinarily directed at individuals who intentionally, knowingly, recklessly, or negligently harm other individuals or property. Concurrence. The criminal act and criminal intent must coexist or accompany another causation. The defendant's acts must cause the harm required from criminal guilt, death in the cause of homicide, and the burning of a home or structure in the case of arson. Responsibility. Individuals must receive a reasonable notice of the acts that are criminal so as to make a decision to obey or to violate the law. In other words, the required criminal act and criminal intent must be clearly stated in the statute. This concept is captured by the Latin phrase "nulla crime sine legea," no crime without law, no punishment without law. The offense's criminal guilt is not imposed to an individual who is able to demonstrate that his or her criminal act is justified or excused. Benefit society, or the individual suffer from a disability that prevented him from forming a criminal intent. We now turn to a specific part of the criminal law to understand the various types of acts that are punished as crimes. Categories of crimes. Felonies and misdemeanors. There are a number of approaches to characterize crimes. The most significant distinction is between a felony and a misdemeanor. A crime punishable by death or by imprisonment for more than 1 year is a felony. Misdemeanors are crimes punishable by less than a year in prison. Note that whether a conviction is for a felony or a misdemeanor is determined by the punishment provided in the statute under which an individual is convicted, rather than by the actual punishment imposed. Many states subdivide felonies and misdemeanors into several cases of degrees to distinguish between the seriousness of criminal acts. Capital penalties are crimes subject to either the death penalty or life in prison. In states that do not have the death penalty, the term gross misdemeanor is used. Some states refer to crimes subject between 6 and 12 months of prison, whereas other misdemeanors are termed petty misdemeanors. Several states designate a third category of crimes that are termed violations or infractions. Those tend to be acts that cause only modest social harm and carry fines. These offenses are considered so minor that imprisonment is prohibited. This includes violation of traffic regulations. Florida classifies its offenses as felonies, misdemeanors, or non-criminal violations. Non-criminal violations are primarily punishable by fine or forfeit property. The following is listed as categories of felonies and misdemeanors. To maximum punishment generally allowed under Florida law: capital penalty, death or life, felony, life in prison, and $15,000 fine. Felony in the first degree, 30 years in prison and $10,000 fine. Felony in second degree, 15 years in prison and a $10,000 fine. Felony in the third degree, 5 years in prison and $5,000 fine. Misdemeanor in the first degree, 1 year in prison and $1,000. Misdemeanor in the second degree, 60 days in prison and a $500 fine. The severity of the punishment imposes a base of seriousness in the particular offense. Florida, for example, punishes as a second-degree felony by the recruitment of individuals for prostitution, knowing that force, fraud, and coercion will be used to cause a person to engage in prostitution. The same act is punished as a first degree in the event the person recruited under 14-year-old or if death results. Mala prohibita. Another approach is to classify crime by moral rectitude. Mala is say crimes are considered inherently evil and would be evil prohibited by the law. This includes murder, rape, robbery, burglary, larceny, and arson. Mala prohibita offenses are not inherently evil and are considered only wrong because they are prohibited by statute. This includes offenses ranging from tax evasion to carrying a concealed weapon, leaving the scene of an accident, being drunk and disorderly in public. Why should we be concerned with classification schemes? A felony conviction can prevent you from being licensed to practice various professions, bar you from being admitted to the armed forces or joining the police, and prevent you from adopting a child or receiving forms of federal assistance. In some states, a convicted felon is still prohibited from voting even following release. The distinction between mala and mala prohibita is also important. For instance, the law provides that individuals convicted of a crime or moral charge may be deported from the U.S. There are a number of other classifications. The law generally categorized as an infamous of crimes that were considered to be deserving shame or disgrace. Individuals convicted of infamous offenses such as treason, betrayal of nation, or offenses involving dishonesty are historically prohibited from appearing as witness at a trial. Subject matter. This textbook is organized in accordance with the subject matter of crimes. A scheme that is followed in most state codes is there is a disagreement. However, concerning the classification of some crimes, robbery, for instance, involves the theft, property, as well as threat or infliction of harm to a victim. That there is a debate of whether it should be considered a crime against property or against the person. Similar issues arise in regard to burglary. Subject matter offenses in descending order of seriousness are as follows: crime against the state, treason, sedition, espionage, terrorism, crimes against the person, homicide, murder and manslaughter, crime against the person, sexual offenses and other crimes, rape, assault, battery, false imprisonment, kidnapping, crimes against habitation, burglary, arson, trespassing, crimes against property, larceny, embezzlement, false pretenses, receiving stolen property, robbery, fraud, crimes against public order, disorderly conduct, riot, crimes against administration of justice, obstructive justice, pre-jury bribery, crimes against the public modesty, prostitution, obscenity. This book also covers the general part of criminal law, including constitutional limits of a criminal law. Chapter 2, sentencing. Chapter 3, criminal acts. Chapter 4, criminal intent. Chapter 5, the scope of criminal liability. Chapter 6 and 7, a defense to criminal liability. Chapter 8 and 9. Sources of criminal law. We have now covered the various categories of criminal law. The next questions to consider are these. What are the sources of criminal law? How do we find the requirements of criminal law? What are the number of sources of criminal law? English and American law. There are English and American judge laws made. State criminal acts. Each state has a comprehensive written set of laws and crime. Municipal ordinances. City, towns, and counties are typically authorized to enact local criminal laws, generally of a minor nature. These laws regulate cities, streets, sidewalks, and buildings, and concern areas such as trafficking, littering, disorderly conduct, and domestic animals. Federal criminal law. The U.S. government has jurisdiction to enact criminal laws that are based on federal government constitutional powers, such as regulation of interstate commerce. State and federal contributions. The U.S. Constitution defines treason and other With the state constitution establishes limits to the power of government to enact criminal laws. A criminal statute, for instance, may not interfere with freedom of expression or religion. International treaties signed by the established crimes such as genocide, torture, and war crimes. These treaties ensure from the basis of criminal law punishing acts such as genocide and war crimes. When Americans are involved, these cases are prosecuted in the U.S. courts. Judicial decisions. Judge writes decisions explaining the meaning of criminal law and determining whether criminal law meet their requirement in the state's federal constitution. Judge typically rely on precedent or decision of other courts in similar cases. At this point, we turn our attention to the common law origins of American criminal law and the state criminal codes. Common law. The English common law is the foundation of American criminal law. The origins of the common law can be traced to the Norman conquest out of England of 1066. The Norman king William the Conqueror was determined to provide a uniform law for England and sent royal judges throughout the country to settle disputes in accordance with the common customs and practices of the country. Excuse me. The principles that composed this common law began to written down in the 1300s in an effort to record the judge made rules that should be used to decide future cases. By 1600, a number of common law crimes have been developed, including arson, burglary, larceny, manslaughter, mayhem, rape, robbery, sodomy, and suicide. These are followed by criminal attempt, conspiracy, blasphemy, forgery, sedition, and solicitation. On occasion, the king and parliament issued decrees that filled the gaps in common law, resulting in the development of the crimes of false pretenses and embezzlement. The distinctive characteristic of the common law is that it's for more part of the product of the decisions of judges in actual cases. The English civil law and criminal law was transported to the new American colleges and formed the foundation of colonial legal society that it was turned to adopt by the 13 states following the American Revolution. The English common law was also recognized by each state, summarily admitted to the Union. The only exception was Louisiana, which followed the French Napoleonic Code until 1805 when it embraced the common law. State criminal code states in the 19th century began to adopt comprehensive written criminal codes. So this movement was based on the belief that in democracy, the people should have the opportunity to know the law. Judges in the common law occasionally punish an individual for an act that had never before been subjected to persecution. A defendant in a Pennsylvania case was convicted of making obscene phone calls despite the absence of a previous prosecution for this offense. The court explained that the common law is sufficiently broad to punish, although there may be no exact precedents. Any act which directly injures or tends to injure the public. There was the additional argument that the power to make law should be resided in the elected legislative representatives of the people rather than in unelected judges. Excuse me. As Americans began to express a self of independence, there was also a strong reaction against being so clearly connected to the English common law tradition, which was thought to have limited relevance to the challenges facing America. As early as 1812, the U.S. Supreme Court proclaimed that federal courts were required to follow the law established but not authorized to apply the common law. States were somewhat slower than the federal government to abandon the common law. In a main case in 1821, the accused was found guilty of dropping the dead body of a child into the river. The defendant was convicted, even though there was no statute making this crime. The court explained that the good morals and decency all forbid this act. State legislators reacted against these type of decisions and began to abandon the common law in the mid-19th century. The Indiana revised statutes of 1852, for example, proclaimed that crimes and misdemeanors shall be defined in punishment fixed by state statutes of states and not otherwise. Some states remain common law states, meaning that the common law may be applied where the state legislator was not adopted a law in a particular area. The Florida Criminal Code states the common law of England in relations, except for as same relates to the mode and degree of punishment shall be forced. No existing provision by statute on the subject. Florida law further provides that where there is no statute, an offense shall be punishable by fine or imprisonment, but the fine shall not exceed 500, no, the term of imprisonment of 12 months. Missouri and Arizona are also examples of common law states. These states' criminal codes, like Florida, contain a reception statute that provides that the states receive the common law as an unwritten part of the criminal code. California, on the other hand, is an example of code jurisdiction. The California Criminal Code provides that no act or omission is criminal or punishment, except as prescribed or authorized by this code. Ohio and Utah are also code jurisdiction states. The Utah Criminal Code states that the common law crimes are abolished and no conduct is made so by this code or ordinance. Professor Lafayette observes that courts in common law states have recognized a number of crimes that are not part of the criminal codes, including conspiracy, attempt solicitation, or uttering gross obscenities in public, sleeping in a house of prostitution, cruelly killing a horse, public garden abrogation, and false imprisonment. You should also keep in mind that the common law continues to play a role in the code of jurisdiction states. Most states' statutes are based on the common law, and courts frequently consult the common law to determine the meaning of terms and statutes. In the well-known California case, Caper versus Superior Court, the California Supreme Court looked at the common law and determined that 1850 state law prohibiting the killing of a human being did not cover the murder of fetus. The California state legislature then amended the murder statute to punish unlawful killing of human being or fetus. More important, the entire approach to criminal charges reflects common law commitment to protecting the rights of an individual in the criminal justice process. State police power. Are there limits on a state's authority to pass criminal laws? Could a state declare that that it is a crime to possess fireworks on July 4th? State government possesses the broad power to promote the public health, safety, and welfare of state. The wide-ranging police power includes duty to protect well-being, tranquility in community, and to prohibit acts or things reasonably thought to bring evil or harm to its people. Example, far-reaching nature of the state police power is the U.S. Supreme Court upholding right of a village to prohibit two or more unrelated people from occupying a single home. Supreme Court proclaimed that police power includes the right to lay out zones where family values, youth values, the blessings of quiet seclusion, and clean air make the area sanctuary for people. State legislators in formulating the concept of criminal have been powerfully influenced by the Penal Code. People from other countries often ask students who study the criminal state law, a country with 15 federal government, that the fact that significant degree of agreement in definitions of crimes in state codes is due to a large extent of the Model Penal Code. In 1962, the American Law Institute, private group of lawyers, judges, and scholars, concluded after several years of study that despite a common law heritage, state criminal statutes radically varied in definition of crimes, were not difficult to understand and poorly organized. All argue that the quality of government should not be dependent on state law facing trial and issue voluminous set of criminal laws. The proposed official draft of the Model Penal Code is currently advisory and is sent to encourage all 50 states to adopt a single uniform approach of the criminal law. The state statutes are accompanied by a commentary that explains how the Model Penal Code differs from existing state statutes. Roughly 37 states have adopted some provisions of the Model Penal Code. Although no state has adopted every single model law, the states that most closely follow the code: New Jersey, New York, Pennsylvania, and Oregon. As you read this book, you might find it interesting to compare the penal code to the common law and to state statutes. This book primarily discusses state criminal law. It is important to remember that we also have federal system of criminal law in the United States. Federal statutes. The U.S. has a federal system of government. The states granted various powers to the federal government that are set forth of the U.S. Constitution. This includes the power to regulate interstate commerce, to declare war, to provide for the national defense, to coin money, to collect taxes, to operate to post office, and to regulate immigration. The Congress is entitled to make all laws which shall be necessary and proper for fulfilling these responsibilities. The states retain powers that are not specifically granted to the U.S. government. The Constitution specifically authorizes Congress to punish the counterfeiting of the U.S. currency, piracy, and felonies committed on the high seas, and crimes against the laws, as well as being rules concerning the conduct of welfare. The Federal Criminal Code complies the criminal laws adopted by the U.S. Congress. This includes punishing acts such as sex offenses, mail-in immigration fraud, bribery in obtaining a government contract, and manufactured defective military equipment. Supremacy Clause of the U.S. Constitution provides a federal law is superior to a state within the national government. That is to previously doctrine. In 2012, the Supreme Court held a federal immigration law prompted several sections of an Arizona statute directed at an undocumented individual. Several recent court decisions have held that federal criminal laws have unconstitutionally encroached on areas reserved for state governments. Federal power to enact criminal laws. For instance, the U.S. government with the Interstate Commerce Clause has interpreted its power to regulate interstate commerce as providing the authority to criminally punish harmful acts that involve the movement of goods or individuals across state lines. An example is interstate transportation of stolen automobiles. The U.S. court has ruled several of these federal laws unconstitutional based on the fact that the activities did not clearly affect the interstate commerce or involve Congress violated the Constitution by adopting the In 1995, Supreme Court ruled in the United States versus Lopez that Congress violated the Constitution by adopting the Gun-Free Schools Act of 1990, which made it crime to have a gun in a local school. The fact that the gun may have been transported across lines is directed with the interstate commerce on which the basis jurisdiction. In 2000, the Supreme Court also ruled unconstitutional the U.S. government's prosecution of an individual in Indiana who was alleged to have set fire on a private residence. The federal law made a crime maliciously damaged or destroyed by means of an explosive. The Supreme Court ruled that there must be a direct connection between a building and interstate commerce. It rejected the government's constitution that is sufficient that a building is constructed of supplies or serviced by electricity that move it across state lines. The owner's insurance payments are mailed to a company located in another state. In 2006, in Oregon v. Gonzalez, the Supreme Court held that the U.S. Attorney General asked for the authority to prevent Oregon physicians acting under the state's death with dying law from prescribing lethal drugs to terminally ill patients who are within 6 months of dying. The sharing power between the federal and state governments is terminally dual. An interesting aspect is dual sovereignty permissible to prosecute a defendant from the same act on both state and federal levels, so long as the criminal charges slightly differ. The double prosecution does not constitute double jeopardy. You might recall in 1991, Rodney King, an African American who was stopped by the Los Angeles police. King resisted and eventually was subdued, wrestled to the ground, beaten, and handcuffed by 4 officers. The officers were all Caucasian in Simi Valley, California, leading widespread protests in southern Los Angeles. The officers were convicted and sentenced to 30 months in federal prison, and 2 were acquitted. Later in the chapter, you will be asked to decide whether this double prosecution is fair. We have seen that the state and federal government possess the power to enact criminal laws. The federal power is restricted by the provisions of the U.S. Constitution that is define the limits on governmental power. Constitutional limitations. The U.S. law, Constitution, and individual states' constitution establish limits and standards for the criminal law. The U.S. Constitution in Chapter 2 requires the following: a state or local law may regulate an area of the federal government. A law may infringe upon the fundamental and civil political rights only in compelling circumstances. A law must be clearly written and provide a notice to citizens and to the police may conduct this is prohibited. A law must non-discriminatory and might not impose cruel and unusual punishment. A law may also re-aggravate and punishment acts that they are committed. The ability of legislators to enact criminal law is also limited by public opinion. The American constitutional democracy. Politicians are fully aware that they must face elections, that they may be removed from office. In the event that they unsupported popular law, we are learned to during the unsuccessful ban of alcohol. Crime in the news. In 1996, California became one of the 23 states to authorize use of marijuana for medical. The other states, Alaska, Arizona, Colorado, Connecticut, Delaware, Hawaii, Illinois, Maryland, Massachusetts, Michigan, Minnesota, Montana, Nevada, New Hampshire, New Jersey, New Mexico, Oregon, Rhode Island, Vermont, Washington, applies the District of Columbia. Maryland exempts medical marijuana users from jail sentences. California's voters passed Proposition 25, Compensation Act 1996, which extended seriously ill residents are able to And marijuana, the act provides an example from criminal prosecutions for the doctors. The California legislation is directly at odds with the Federal Controlled Substance Act, which declares a crime to manufacture distribute marijuana. There are more than 100,000 medical marijuana users in California, and roughly 1/10 of the population uses marijuana in the states that collect information. Hingo Wright and DYanez are two California residents who suffer from severe disabilities. Their doctors have found marijuana is the only drug to calm pain and suffering. Rach's doctors go so far to claim that Angel's pain is so intense that she might die if deprived from marijuana. Mason cultivates her own marijuana, and Rach relies on two caregivers who provide her with California marijuana at no cost. In August 2000, agents from the federal drug from the DEA raid Monson's home and destroyed all her 6 marijuana plants. The DEA agents disregarded objections from the Battle Blue Sheriff's Department and local California District Authority that Mason's possession of marijuana was perfectly legal. Mason and Rach, along with several doctors, refused to accept destruction of marijuana plants and asked the Supreme Court to rule the Constitution to refuse to accept medical marijuana uses from criminal prosecution. The case was supported by the Medical Association and Leukemia and Lymphoma Society. They suffered from severe chronic pain stemming from borrelia, endometritis, soleus, uterine fibrillary tumors, radial cuff stream syndrome, pain, brain tumor, seizures, life-threatening wasting syndrome, and constant nausea. She also experienced extreme chemical sensitivities that are related violent or allergic reactions to virtually every pharmaceutical drug. Rach was also confined to a wheelchair. A doctor recommended that Manson use marijuana to treat severe chronic back pain and spasm. She alleges that marijuana alleviates the pain that she describes as comparable to uncontrollable crime. Manson claims that other drugs have proven inactive. The U.S. Supreme Court in Gonzalez v. Rage in 2005 held that federal prohibition on the possession of marijuana would be undermined by exempting marijuana possession in California and other states from federal criminal enforcement of marijuana under California's medical marijuana law. Although clearly local activity frustrated the federal government's effort to control the shipment of marijuana across state lines, because medical marijuana eventually would cross its way interstate commerce, increase the nationwide supply, and drive down there was also a risk that completely health individuals in California would manage to fraudulently certified by a doctor to be in need of marijuana. Following the decision, Angel Range urged the federal government to have some compassion and have some heart, not to use taxpayer dollars to come in and lock us up. Because she asked why the federal government was trying to color. Opponents of the marijuana defend the Supreme Court's decision and explained that individuals should look to traditional medical marijuana rather than being misled. The Obama administration initially did not enforce federal marijuana laws until individuals in marijuana states. In 2011, Departments of Justice announced that individuals could grow and use small amounts of medical marijuana, that they would prosecute growers more than 100 plants. In 2013, the Obama administration reversed course and announced that it would not prosecute individuals in medical marijuana states unless the individuals certain federal law enforcement interests. This included the distribution of marijuana to minors. In 2014, Congress adopted a law prohibiting the Justice Department from using the resources to prevent states from implementing their own state laws. Of course, the democratic will of the majority is subject to constitutional limits. A classic example in the Supreme Court's that the popular state prohibit beating and punishing the flag burning, compose an unconstitutional violation of freedom of speech. Considering the factual scenario that is taken from the U.S. Supreme Court's description of the events surrounding the beatings of King, you decide. On the evening of March 2, 1991, Ronnie King and two friends sat in King's wife's car in California. City of Los Angeles County drank malt liquor for a number of hours. Then, within With King driving, they left Altina Freeway. King was intoxicated. California highway. Officers observed King car traveling at a speed of estimated to be in excess of 100 miles per hour. The officers followed King with red lights and sirens activated and horned him with a loudspeaker to pull over. He continued to drive. They radioed the unit for help. Angeles Police Department joined in the pursuit. One of them manned the petitioner Lawrence Paul and his trainee Timothy Wynn. The officers are all Caucasian. King is African American. King later explained that he fled because he feared that they would be returned after being released 4 months earlier, following a year spent behind bars for robbery. King left the freeway after a chase of about 8 miles, stopped at an entrance or recreation area. Officers ordered King and 2 passengers to exit the car and sue felony-prone positions. King's 2 friends complained. King, too, got out of the car but did not lie down. Petitioner Stacy Kuhn arrived at once, followed by Ted Brisnell, Rolando. All were officers of the Los Angeles Police Department, and Sergeant Combs took charge. The officers again ordered King to assume felony-prone position. King died on his hands but did not lie down. They tried to force King down, but King resisted and became combat. They fired tasers, darts into King. The event that occurred next were captured on videos by bystanders. Videotape shows King rose from the guard, charged toward Officer Paul, took a step, used baton, and hit him in the head. King fell to the ground from 18th to 30th. He attempted to rise, but Powell and Wynn struck him with the batons from 35th to 51st. Second, Powell administered repeated blows to lower extremities, and one of the blows fractured King's legs. At the 55th second, Powell struck King on the chest, and King rolled over, played prone. At the point, the officer stepped back, observed King for about 10 seconds. Powell began to reach for his handcuffs. At the sentence he faced, the district court found that Powell no longer perceived King to be a threat at this point. At 1 minute 5 seconds, the videotape Brisnell District Attorney stomped on King's upper back or neck. King's body shivered in response. 107, Powell and Wynn began to strike King with a series of baton blows and Wynn kicked in the upper thoracic cervical area. 129, King put his hands behind his back and was careful. Powell radioed for an ambulance. He sent 2 messages over communications networks to another officer that says, "Oops, and I haven't beaten anyone this bad in a long time." Coon sent a message to the police station so that unit had just been big time use of force. Teased and beat to the suspect of CHP presumed big time. King was taken to a hospital, treated for fractured leg, multiple facial features, and number bruises, contusions. Learning that King worked at Dodger Stadium, Powell said, "We played a little ball tonight, didn't we, Ronnie? You know, we played a little ball. We played a little hard ball tonight. We hit a few home runs. Yes, we played a little ball, and you lost. We won." Cool. Powell blindly was tried in California State on charges of assault with a deadly weapon, excessive use of police officers. The officers were carried by all our charges with the exception of 1 assault charge against Powell with a start a hung jury. The jury composed of 10 Caucasians, 1 Hispanic, and 1